Hello, and welcome to today's session. Learning Outcome LO1. Understand key concepts and themes in the development of employment law and contracts. Today, we will explore a fundamental question. What is the significance of employment law in today's workplace? This session will take you through the evolution of employment law, highlighting how it has developed to protect both employers and employees. We will examine the essential elements of employment contracts and the legal frameworks that promote fairness, equality, and proper workplace conduct. By the end of this lesson, you will understand how employment law shapes working relationships and ensures that rights and responsibilities are clearly defined for all parties involved. This unit introduces the basics of employment law relevant to businesses. You'll learn how to apply the law to various employment situations. Understand the meaning and effects of employment contracts. Explore laws related to equality, discrimination, and redundancy. Stay updated with the latest employment laws for comprehensive knowledge. Employment law in the UK has transformed significantly over time. Initially, it favored employers under the master and servant concept. Industrialization and trade unions pushed for better working conditions. Key legislation like the Factory Acts marked shifts towards employee protection. This evolution continues to shape modern employment law. Employment law balances employer-employee relationships by setting minimum standards. It aims to protect workers from unfair treatment and promote safe work environments. Equality and dispute resolution are central goals. Employers benefit from clear legal frameworks. This ensures expectations and reduces litigation risks. UK employment law derives from multiple sources. Statute law includes acts like the Employment Rights Act. Common law offers judicial precedents. European law influences remain post-EU exit. Employment contracts and collective agreements further define terms. Together, these sources create a comprehensive legal landscape. An employment contract is a binding agreement detailing work terms. It covers job duties, salary, and working hours. Contracts may include express and implied terms. Breaches can lead to claims like constructive dismissal. Understanding these contracts is vital for both parties to maintain fair relationships. Modern employment law emphasizes equality and diversity. Work-life balance laws reflect societal changes. Health and safety are statutory duties. Data protection is crucial in digital workplaces. Employment status debates arise with gig economy growth. These themes address evolving challenges in the workplace. Employment tribunals resolve disputes like unfair dismissal. ACAS promotes good industrial relations. The Health and Safety Executive enforces safety laws. The Equality and Human Rights Commission ensures compliance with equality law. These bodies support fair and lawful employment practices. Employment contracts form through offer and acceptance. Consideration involves exchange of labor for wages. Legal intention is presumed in employment. Capacity ensures parties can legally contract. Legality of purpose confirms the work is lawful. These elements create valid and enforceable contracts. Express terms are clearly stated, like job duties and pay. Implied terms are understood through law or custom. They include mutual trust and a safe workplace. Breaches can lead to disputes. Written statements outline key employment details. Supporting contractual terms. Employment law applies differently based on status. Employees have full rights, including unfair dismissal protection. Workers have basic rights like minimum wage. Self-employed individuals have limited protections. Correct classification is crucial to avoid legal disputes. Contracts end through notice or mutual agreement. Dismissal requires a fair reason and procedure. Constructive dismissal occurs from employer breach. Frustration ends contracts due to impossibility. Legal compliance is essential to avoid disputes. Breaches occur when terms aren't fulfilled. Employers may breach by not paying wages. Employees can breach by misconduct. Serious breaches lead to dismissal claims. Remedies include compensation or reinstatement. Unfair dismissal lacks a fair reason or process. Employees need 2 years' service for claims. Fair reasons include capability and redundancy. Procedural fairness is crucial. Automatically unfair dismissals protect certain rights. Constructive dismissal involves resignation due to employer breach. The breach must be fundamental. Resignation must be a direct response. Delay in resigning may imply acceptance. Proving constructive dismissal is challenging. Unfair dismissal is employer-initiated without fairness. Constructive dismissal is employee-initiated due to breach. Both protect against unjust termination. Fairness and mutual trust are central. Legal claims depend on proof and circumstances. Wrongful dismissal breaches contract terms like notice. It's a contractual, not statutory claim. Employers must provide proper notice or payment. Gross misconduct justifies summary dismissal. Remedies focus on notice period compensation. Wrongful dismissal focuses on contract breach. Unfair dismissal considers fairness and procedure. Wrongful claims can be made by any contracted worker. Unfair claims need 2 years' service. Both require different legal approaches. Evaluating scenarios helps predict legal outcomes. Consider employer actions and employee rights. Legal breaches can lead to tribunal claims. Following procedures reduces disputes. Understanding implications aids in legal compliance. Sarah's dismissal lacked fair process and notice. She claims unfair and wrongful dismissal. Employer failed to follow ACAS code. Stress and workload issues were ignored. Legal outcomes favor Sarah due to procedural failures. In conclusion, this knowledge underpins a fair and legally compliant employment relationship. Should you have any questions, you are welcome to reach me by text or phone on 07000 484 361,688. Thank you for your time, and I look forward to our next session.